Hi, everybody. It's great to have you all here. We're just going to wait maybe one more minute to see if more people join, and then we'll get started with this afternoon's webinar. Okay, great. Just give me 1 second. Great. So good afternoon, everyone, and thanks so much for joining us for today's discussion on challenging security and admissibility in Canada's immigration system. My name is Tim McSorley, and my pronouns are he, him. Before going further, I'd like to just take a moment to acknowledge the territory that I'm joining you from today. I'm zooming in from Ottawa, which is the ancestral and unceded territory of the Algonquin Anishinaabe people. It's important that we center decolonization in our efforts to address the impacts of Canada's national security and immigration laws, recognizing especially how they have served to further colonialism in Canada as well as internationally. I'm the national coordinator with the International Civil Liberties Monitoring Group. We're one of the 3 co-organizers of today's event, along with the Canadian Council for Refugees and the Canadian Association of Refugee Lawyers. I'd like to thank my co-organizers, Janet Dent of the CCR and Abdiaziiz of Carl, for all their work on putting together today's panel. Bonjour tout le monde. Merci beaucoup d'être ici avec nous pour cette discussion concernant l'interdiction de territoire pour motifs de sécurité. Mon nom est Tim, pronom il. La conférence d'aujourd'hui aura lieu en anglais, mais nous partagerons des versions françaises des diapositives pour celles et ceux qui aimeraient les avoir. Vous pourrez les trouver dans la section Documents à distribuer ou Handouts dans le panneau de contrôle que Janet vous montre sur l'écran présentement. Normalement, ça va apparaître à la droite de votre écran. Si c'est en anglais, ça veut dire Handouts et il devrait y avoir 3 fichiers disponibles. Et en français, ça veut dire Documents à distribuer. Aussi, n'hésitez pas quand ça vient à la période de discussion de partager vos opinions, suggestions et questions en français et on les traduira. For those who don't speak French, I was just explaining that while this webinar will be in English, French translations of speakers' notes are available in the handouts area of your screen. People are also invited to ask questions in French and we'll translate them for those who don't understand French. A few more logistical points before we get into the heart of things. We'll have presentations about 12 minutes each from each of our 3 resource people. After that, we'll have a discussion on the issues, and especially how we can work together to challenge the problems with Canada's security and admissibility system. I'll be facilitating the first part, while Amanda from Carl will facilitate the discussion period. We invite you to use the question box to write your questions and indicate if you want to speak. Otherwise, we can read it out. We also plan to record all of today's event. We hope to share the presentation portion publicly. And while we'll be recording the discussion period, this is just for internal purposes, so please don't be worried that your questions or comments will be shared outside of today's discussion. We also plan to share the speaker's slides after the event for those who are interested. Also, a big thanks to Janet from CCR, who's going to be monitoring questions during the discussion and is making sure everything runs smoothly today. So now on to the main reason we're all here, and that's challenging Canada's security and admissibility system. Canada's security admissibility regime is deeply problematic. It labels non-citizens as security threats based on broad and vague grounds, with severe and lasting impacts on those caught up in the system. Among those most impacted by security admissibility are refugee claimants who have faced persecution for being involved in opposition political movements. Branded as enemies of the state at home, upon arrival in Canada, they are labeled security risks and barred from making a refugee claim. They then face a possibility of being deported to a dangerous situation. Today, we're joined by 3 fantastic speakers to tackle this subject: Sharry Aiken, Warda Shazadi Meighen, and Wasim Ahmed, who have all agreed to share their extensive expertise in immigration and refugee issues, and particularly Canada's security and admissibility laws. We'll start today with Sharry Aiken, a law professor at Queen's University and a former president of the Canadian Council for Refugees. Her understanding of the injustice of the justice system was formatively shaped by her experience over 20 years ago, representing 2 Kurdish refugees who are alleged to be members of a terrorist organization. Sharry will present an overview of the ongoing and long-standing problems with Canada's security and admissibility system. Next, we'll hear from Warda Shazadi Meighen, a partner at Landings Law, an immigration, refugee, and human rights law firm based out of Toronto. She is currently representing CCR and Carl as counsel in the Ali case. She holds a graduate degree from Oxford University, where she focused on refugee, migration, and international refugee law. Warda has published work in the areas of the criminalization of migration and has an upcoming chapter on inadmissibility. She has been recently named as a leading lawyer in Canada under the age of 40, and she is an adjunct professor of refugee law at the University of Toronto Faculty of Law. Warda will present the legal challenge in the case of Abdiaziiz Mohamed Ali, who arrived in Canada in 2015 as a refugee claimant after facing persecution by Ethiopian authorities for support of Ogaden opposition movements. To close things out, we'll hear from Washim Ahmed, a refugee and immigration lawyer and co-founder of OWS Law, a full-service law firm. Washim is a member of the Canadian Bar Association's Immigration and Refugee Board Consultative Committee. Washim has worked extensively in the area of security and admissibility and has represented dozens of clients who were alleged to be members of terrorist organizations due to their affiliation with the Bangladesh Nationalist Party and Jamaat-e-Islami, which are the two main opposition political parties in Bangladesh. Washim will present the case of Abdurrahman El-Mahdi, an Egyptian national who arrived in Canada as a refugee claimant in 2017, fleeing persecution by Egypt's military government for his participation in protests against the former Mubarak dictatorship and his membership in the Freedom and Justice Party. Finally, we'll end with a discussion, which is really the goal of today's event. As you'll hear, the problems with this system are not new. While there are court challenges of the system that are taking place, court decisions alone won't suffice. We're interested in speaking about how we can work together to develop advocacy tools and campaigns to bring the pressure necessary to end the problems with this system once and for all. And so, given all that, and without further ado, I'll pass things along to Sharry Aiken. Sharry?
Thank you very much, Tim, and a special thanks to the organizing associations for this very important webinar. So, security inadmissibility. Here are the key takeaways, and I always like to begin with the takeaways to hopefully organize our thoughts together. So you will see very quickly that I am extremely critical of the security inadmissibility regime writ large. I think it is deficient from a rule of law perspective for the following 4 reasons. Essentially, it renders people inadmissible based on guilt by association, a concept that is anathema to the rule of law. It often bases those decisions on either secret evidence or a highly selective rendition of that evidence. It has all the hallmarks of a lack of due process, in other words, a lack of fair procedures for the person concerned, and a lack of an effective remedy in relation to those deficiencies. And finally, but frankly, I could really say primarily, it's a shining example of systemic racism in action in terms of who is detrimentally impacted by Canada's security inadmissibility regime. So those are the key takeaways, and now I'm going to provide you with the evidence for that. And I want to start by referencing the secret trial 5. I suspect many of you have heard of the 5 men of Middle Eastern descent who were collectively branded as terrorists by the Canadian state and spent together nearly 30 years in prison combined without being charged with a crime. These were individuals who were alleged to be associated with terrorist organizations pursuant to Canada's immigration and refugee protection, security inadmissibility provisions. And I want to say their names: Hassan Elmre, Adil Sharkawi, Mohammed Harkat, Mahmoud Jabala, and Mohammed Majoub. In fact, of the 5, only 2 cases have been resolved to date. The others are still in varying stages of engaging with the Canadian state. Maybe you could say 3 are resolved in the sense of no longer at risk of deportation. 2 remain very active. And let's take a look at who we're talking about for 1 second. Next slide, please. These are the 5 individuals. So these individuals were subjected to the security certificate regime. And as a result of successful constitutional challenges and some changes made to those procedures, the government has found it a little bit awkward to proceed with security certificates today. Indeed, no new certificate has been signed or issued since 2016. Instead, the government is resorting to what are called ordinary security and admissibility procedures. Next slide, please. So when I say ordinary, those are provisions in the Immigration and Refugee Protection Act that bring people to the Immigration and Refugee Board for a hearing if they're alleged to be inadmissible. Now, this is not a new and improved procedure. Frankly, it's characterized by most of the same problems of the security certificate regime. But instead of a judge holding all the cards, it's a member of the Immigration Division of the Immigration and Refugee Board, someone who may not even be a lawyer, actually, making a decision about whether, for example, a refugee claimant will be allowed to proceed with their refugee claim or will be barred permanently from doing so. Next slide, please. So we need to look at where the legal authority for these procedures are coming from. And they're actually found in Section 34 of the IRPA, the acronym for the Immigration Refugee Protection Act. And those provisions cast a very wide net. Let's take a look. Next slide, please. So according to Section 34, a person is inadmissible on security grounds if they engage in various acts of espionage, subversion, or terrorism. Okay, engaging in various acts. That in and of itself may not be that problematic, but interestingly, those provisions are used rather sparingly in relation to non-citizens, and in particular in relation to refugee claimants. Much more commonly invoked is the subclause, Section 34(1)(f), which identifies people as inadmissible if they are or were a member of an organization that has engaged in espionage, subversion, or terrorism. Now, membership is not defined in the Immigration and Refugee Protection Act or in the regulations. Jurisprudence by many different levels of courts, including the Supreme Court of Canada, has confirmed that membership should be given a broad and unrestricted interpretation. This approach to membership is actually very divergent from criminal law approaches to complicity and inchoate offenses, which are sort of the preliminary steps before an offense is actually formalized and completed. In fact, the way that membership is treated in immigration law is almost akin to a status offense, something that's anathema to criminal law concepts and rule of law more broadly, the idea that somebody is criminalized by virtue of their status or their identity. Next slide, please. So this broad interpretation, what are the implications? Well, first of all, there's no requirement of involvement or even knowledge of the prescribed acts. There's no temporal component. In other words, that wide net I showed you the image of, it catches both past involvement in an organization that later committed human rights violations long after someone left, and also recent involvement in an organization that long ago gave up violence. It matters not one bit whether the temporal connection is faded and indeed barely existent. As long as there's a connection to the organization, past, present, or future, it's enough to catch the person in the inadmissibility net through membership. Next slide, please. The other thing you need to know is that there's also a provision in the Act which emphasizes that the legal test for finding someone inadmissible on security grounds is something called reasonable grounds to believe. That's a hair above mere suspicion. We probably are familiar with the concept of balance of probabilities, which is the more usual threshold in the civil context, in other words, the non-criminal law context. But in relation to inadmissibility in immigration law, it's a far lower threshold, which means it's much easier to catch someone in that wide net based on reasonable grounds. It doesn't need to be, clear and compelling. It merely needs to be reasonable. It doesn't need to be correct. It merely needs to be reasonable. And the other thing we need to know is that that decision in relation to reasonable grounds is subject to review by a federal court judge on reasonableness, which means that we have multiple layers of a very low level of scrutiny in relation to that initial finding of membership. Next slide, please. So just to give you an example, and I think it's really a case in point, I know my colleagues on the panel are going to be going into more detail about two recent cases, but I actually want to share just briefly the facts of one case which I think illustrates the problem in a pitch perfect way. And it's the case of Sugunam Joseph, Sugunam as she's called by people who know her. So Ms. Joseph was the 74-year-old widow of a Sri Lankan parliamentarian, a member who had been democratically elected to the Sri Lankan parliament, member of the Tamil National Alliance. Ms. Joseph was alleged to be a member of the LTTE or Tamil Tigers. She was neither a member of the Tigers nor in any way engaged with the Tigers. She supported the activities of her late husband. Now, as I mentioned, this case is a pitch perfect example of the problems. She was ultimately exonerated and ultimately granted permanent residence. But the ultimate irony is to consider the fact that Ms. Joseph was actually facilitated to come to Canada by the Canadian government. She was issued a prompt visa in the immediate wake of her husband's assassination in Sri Lanka. One arm of the Canadian state recognized Ms. Joseph was a refugee in need of protection, but the other arm, informed by the findings of CSIS, decided that Ms. Joseph was essentially guilty by association to her husband. Really a crazy case. While it was ongoing, I spoke about it publicly at every opportunity because I think it demonstrated really clearly what was deeply problematic about the security and admissibility provisions. Next slide, please. So what are the consequences of being found inadmissible under Section 34(1)(f) as we've been just discussing? Well, I'm sure we can go into some of this in a little bit more detail, but in a nutshell, the consequences are essentially permanent. They are almost impossible to revoke. We mentioned the fact that refugee claimants are affected. They become ineligible to pursue their refugee claims. They are at risk of removal. It goes without saying that they will be denied permanent residence and rendered into a state of legal limbo for years, with associated stigma because being branded as a potential member of an organization involved in terrorism or subversion has deep and very profound consequences for individuals in their ability to just live their lives. It's also important to recognize that they're rendered very often into a state of indefinite surveillance and of course are unable to reunite with family members, either sponsor families members to come to Canada or travel outside of Canada to see family members. I can share the case of one client's story who I'm very familiar with, who hasn't seen his mother for 30 years now because he's been languishing in security inadmissibility limbo. He's unable to leave the country because he'll be at risk of not being allowed in. And of course, he can't even sponsor his mother for a visit to come to Canada. Next slide, please. So the remedies, and this is really where I want to end. Next slide, please. You see the needle in a haystack. It's for a reason. So I mentioned the fact that if someone's branded inadmissible by the Immigration Division, they have no right of appeal. The minister can appeal, but the person concerned can't. Their only recourse is judicial review. But because federal court judges review the findings of the Immigration Division with very little scrutiny, essentially just looking to see if the member got the decision not correct, but basically that it was reasonable, they're pretty hands-off. They uphold the findings of the Immigration Division more often than not. The person concerned has no access to humanitarian and compassionate relief, which is a remedy available to other people who have trouble with various provisions of the Immigration and Refugee Protection Act. Instead, they have something called ministerial relief. That's set out in Section 42(1) of the Act. Next slide, please. So the interesting thing about ministerial relief, it's not much relief at all. It's highly discretionary. The onus lies on the person concerned rather than the minister to establish that they qualify. And by the way, it doesn't matter whether they don't pose any actual threat to public safety or national security. One would think that that would be the overriding concern, but it's actually not. Any relevant security concerns are part of the assessment. And the other thing to note is the person can't actually initiate an application for ministerial relief until after any ongoing challenge to inadmissibility is over. Next slide, please. So the government likes to talk about ministerial relief as a safety valve. I would suggest that it's no safety valve at all. And in fact, the statistics are rather telling. The one that I really want to mention is that the average processing time for a ministerial relief application is 10 years. And it's 10 years whether we look at the most recent statistics that the government is offering in one of its reports from last year, or whether we're looking at earlier statistics back from 2009. It's 10 years before a decision is made, which means 10 years in legal limbo. Final slide, please. So the last thing I'm going to end with is just underscoring what, from my perspective, all this amounts to: systemic racism. And it also tracks the problem back to the role of the Canadian Security Intelligence Service, which is responsible in the first place for identifying security threats and plays a pivotal role. So let's contrast the treatment in Canada of refugee claimants and others who are branded as inadmissible on security grounds through the membership provisions versus the temporary resident permits and admission via national interest letters that the government routinely affords to high-profile foreign nationals who would otherwise be barred from entry due to human rights violations. If you look at government statistics, you see the government actively encouraging the admission of its friends to come to Canada, despite having blood on their hands, despite being complicit in human rights violations. But refugee claimants and others who've been disproportionately from the global south, and in particular, if we look at the stats available from 2002 to 2013, we see 4 countries of origin accounting for the majority of all inadmissible cases on security grounds: Sri Lanka, Pakistan, India, and Iran. I think the statistics speak for themselves in this regard. I think security inadmissibility as it currently stands is both flawed in principle in terms of the provisions that are in the Act and how security inadmissibility is defined, and it's also flawed in terms of its procedures, in terms of the lack of due process for individuals affected, the lack of appropriate review and appeal mechanisms, as well as the lack of any genuine remedy. So I'll end there, other than just maybe, Tim, fast forward to the next slide. Oops, we're gone. Okay, the next slide is really the note that I wanted to end on, if you don't mind. The very next slide. Yeah, that's what we're going to talk about in the discussion. Thanks very much.
Thanks so much, Sharry. That was really excellent. And next we'll move on to Warda. Warda, I think you're still muted.
Hi, is this better? Okay, great. Thank you very much, Sharry. That was a fantastic overview and a great segue into the specific case that I will talk about, and that is Ali, Canadian Council for Refugees, and Canadian Association for Refugee Lawyers against and Government of Canada. And this is a case that we are quite passionate about, that CCR has taken on, as well as Carl, as public interest parties, and they've been added as public interest applicants. And it's an attempt to try to chip away at the unfairness and injustice that is underlying Section 34 1F in particular, and also the entire inadmissibility regime that surrounds that section. So in my short presentation, I will speak about 5 things. I will talk to you about the facts of Mr. Ali's case. I will talk to you at a very high level about the overall theory that we have of the case in terms of the legal arguments. I will talk about the individual witnesses that we have been able to add to the record as evidencing the impacts that Sharry spoke to. I will also talk about the expert witnesses that we have been fortunate to gather that speak about the issue in the inadmissibility regime from various standpoints. And lastly, I will talk about what CCR and Carl are hoping to accomplish with their involvement in this litigation. So the facts of Mr. Ali's case are that he is a young person from Ethiopia. He came to Canada from Ethiopia at the age of 19 and claimed refugee status at arrival. And it's been over half a decade now, and he has not been able to get a refugee determination, but instead he's been subject to a number of things, including over half a decade of mandatory reporting requirements under the threat of detention. And so, as Sharry was mentioning, his refugee claim has been suspended pending the determination of whether or not he is inadmissible under Section 34 1F of the Immigration and Refugee Protection Act. That's that wide net catch-all provision that Sharry was speaking about. So why does the government think he's inadmissible? In his specific case, he was in grade 8. He ran along with his family's convenience store. So imagine a roadside convenience store in Ethiopia, and while he was helping his family run this convenience store, he allowed for a donation box to be kept at his store. He never solicited donations. He has not been associated with this organization called the Ogaden National Liberation Front, but the donations did go to that organization. And they were things like cigarettes, food, sugar, some money, nothing really, high level in terms of financing terrorism at all. The government thinks that ONLF, the Ogaden National Liberation Front, is a terrorist organization. And it is in fact a separatist organization in Ethiopia, and it's an organization fighting for the self-determination of the Ogaden peoples. But regardless of whether one classifies it as an organization that the government has reasonable grounds to think is engaging in terrorism, or has or will, or not, Mr. Ali has claimed the entire time that he's not a member. So the only connection he has is this minimal connection of keeping a donation box where he did not actually solicit donations. And that is the act that captures him within the security and admissibility regime under 34 1F that Sharry was speaking about. So next I'll talk about the overall theory of the case. I've been advised to not go into the nitty-gritty of the legal arguments, which lawyers love to do, so I will keep it at a very high level. So our theory of the case is, on a number of grounds, we're arguing that this inadmissibility process, the entire process around 34 1F, violates individuals' charter rights under Section 7 and 12 of the Charter, as well as the due process guarantees that they have under a quasi-constitutional instrument known as the Bill of Rights. So I will just very briefly at a high level talk to you about what the contours of our arguments are. So Section 7 says, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principle of fundamental justice. We are arguing in this case, so CCR and Carl, along with Ali's counsel, that Mr. Ali's right to liberty is being violated for a number of reasons. Number one being that he is subject to mandatory reporting under the threat of detention without ever having an assessment of fault, right? So no one has ever said you are a terrorist. No one has ever said you are a member of this organization, but there are reasonable grounds to believe, that's all they've said, there are reasonable grounds to believe that you're a member of this organization. So we are arguing that labeling Mr. Ali with this very heavy stigmatizing terrorist label where there's been no assessment of fault is a violation of the principles of fundamental justice. And of course, his liberty is impugned because he is subject to mandatory reporting under the threat of detention. We've also developed arguments on a number of other liberty grounds, but they follow a similar rationale, so I won't go into each one of them. In terms of the security of the person, which Section 7 guarantees, we are arguing that the psychological implications for folks like Mr. Ali who are caught in this awful regime is tremendous. And I will get into this with our expert evidence a little bit, but the stigma, again, of being labeled a terrorist, for example, or the psychological harm that flows from knowing that the government of Canada is branding you with this label is a violation of the security of the person. And this violation is not in accordance with the principles of fundamental justice. And we're arguing that the principles of fundamental justice require that a law not be overbroad, for instance. So there has to be some connection between what Mr. Ali did and the purpose of the legislation, which is safeguarding national security. But there's none of that, right? So it's cast so wide that it becomes quite removed from the harm that we're actually trying to get at in 34(1)(f). So for these reasons, we are arguing that there is a violation of Section 7. We're also arguing that there's a violation of Section 12. Section 12 of the Charter states that everyone has the right not to be subjected to cruel and unusual treatment or punishment. And we're arguing that the treatment to which Mr. Ali and those like him are subject under 34(1)(f) and the regime that surrounds it is cruel and unusual, in that it would violate, it would shock the conscience of the public if they understood what he was actually going through versus the risk, for example, that he poses. We're also dusting off the books for a Bill of Rights argument. The Bill of Rights is an instrument that predates the Charter, and most of it has been taken over by the Charter, but there are some grounds that remain, and the one that I will focus on is 2E. So Section 2E of the Bill of Rights says that where a person's rights or obligations fall to be determined, that the person has to get a fair hearing. And if they don't get a fair hearing, it has to be in accordance with the principle of fundamental justice. So we're arguing that he is, obviously his rights and obligations are triggered under this regime, and he does not get a fair hearing because at no point is there an assessment of his individual fault before he's subjected to these mandatory reporting requirements under the threat of detention. So I want to take a minute to talk about the individual witnesses in this case for two reasons. One is that it really humanizes the process. And you saw this with Sharry's slides as well, that there are real people who are behind this. Some of these clients have been representing for several years now, and you become quite attached to them, and you really start seeing all of the implications that the security and admissibility process has on their lives, from whether they can see their family or how they perceive themselves. And they start to, a number of them go into psychological conditions where it's like learned helplessness, and they just, they feel so paralyzed by the entire process. And then a number of them are quite anxious each time their work permit comes up for renewals. So some of my clients can't get, 3-year or 4-year work permits. They have to renew them every year because they're caught in these proceedings. And so every time renewal time comes up, they're freaking out because it's, the only way they can make a livelihood. They have to pay exorbitant fees to get these work permits, which is a significant part of their family's budget. I can go on and on, but to be close to people who are completely enveloped in the problems created by this process for a purpose that is so removed from what we're actually trying to target. It's just, it's quite unbelievable. So the witnesses we have in this case, I also want to talk about because CCR and Carl have done a lot of work in helping us get these witnesses. A number of these witnesses were actually already in the record. Mr. Ali had fantastic counsel before the team was expanded, and so some of them come from that work. So the connection these folks have to potential inadmissibility areas of concern are for these types of acts. Person number one was doing humanitarian work to support refugees. Person number two was spending time teaching children at a school that was loosely connected to the Eritrean liberation movement. Person number three was distributing pamphlets as a teenager for the Mujahideen al-Khalq. Person number four was involved in the Bangladesh National Party, but only with respect to its humanitarian efforts. And I want to just pause for a minute and talk about this dynamic that plays out over and over again in our cases. And I believe Washim will pick up on this as well, because he represents a lot of folks who are Bangladesh National Party members or alleged members. But one of the problems that happens with these systems is that in certain countries, there are only two political options. So for example, in Bangladesh, there's the Bangladesh National Party or there's the Awami League. And if you want to be politically active, you are going to be with one of those two organizations, and they're both engaged in violence. And so it's not like joining the NDP or the Liberal Party or the Conservative Party. Those are not the types of options that folks in other parts of the world are often confronted with. So witness number four was involved in the humanitarian branch of a local BNP party branch, and that's why he's caught in inadmissibility proceedings. In terms of the expert evidence that we've been able to gather, we are arguing that Section 34(1)(f) and the regime that surrounds it violates international law. And the argument here is really that the Refugee Convention, to which Canada is a signatory, is exhaustive, and it sets out what our obligations to refugees are. And it contemplates a process for excluding refugee claimants that aren't deserving of Canada's punishment. Those are folks that have been involved in crimes against humanity or war crimes, for example. And in those instances, there is a process and there are burdens of proof that have been upheld by the courts to mete out that type of exclusion from the Refugee Convention. And we have experts in the UK and EU that attest to the fact that that is in fact what happens in those jurisdictions. The Refugee Convention is exhaustive. But in Canada, we've created this parallel, vague, broad regime that captures everyone under the sun. And we argue that it actually violates international law. And so we have expert evidence to that effect. We also have been able to get, my colleague Joshua Bloom did a fantastic job at getting a stigma affidavit that likens what folks are going through in 34(1)(f) to the no-fly regime that exists, and all the stigma for members of the Muslim community, for instance. So where a person is Muslim, Middle Eastern, a person of color, and they then have this terrorist label imposed on them, what that does to them psychologically and practically. And the expert evidence is quite good at describing that. So why are we involved in this is my last slide. What can you do? What are we trying to do here? Our goal, legally speaking, is to either strike down this Section 34(1)(f) and the regime that surrounds it. But if that doesn't work, we hope that the court will read in some sort of limitations so that the net is not cast as broad. We're also hoping that the evidence we gather, for example, through experts, will be used in other advocacy that CCR and Carl are engaged with down the line, because these court cases don't always go the way we want, obviously. And number four is really where you come in, and where we're hoping that the discussion will allow for more of a discussion around. it's to mobilize the community. So the last time CCR did a presentation on this topic, a number of people came to council in the litigation and were able to connect us with witnesses that provided very helpful evidence in this litigation. So that's a very obvious way that people can become involved, but you have a very unique role in intersecting with refugees and migrants. And these issues do come up in their community. So when they do, you can become good advocates with them in terms of going to their MPs, explaining to them the unjustness of this process, perhaps writing opinion pieces for newspapers, with the relevant backgrounds and facts, and obviously the consent of the folks you're helping. And then just engaging in long-term informed discourse about how unfair and unjust and un-Canadian, I would argue, that these laws really are. And subject to any comments, those are the only things I have to say.
Thanks so much, Warda, and thanks for all the work that you and the rest of the legal team are doing on this case. It's so really important. And next we'll go to Washim.
Thank you. You can see my screen, right?
Yes, we can, yeah.
Yeah, okay, perfect. Thank you. So thank you very much. I'm really humbled to be here today, speaking at this event with two great professionals, Sharry and Warda. You have done fantastic work in this area. I would like to thank especially the organizers today. You guys have put a very wonderful event, and all the people who have been participants who have been participating with your patients. Thank you. So I would like to talk about the case of Abdurrahman Al-Mahdi, an Egyptian citizen. And Abdurrahman's case is actually an example of everything is wrong with the 34-1F regime that we have. Everything that Sharry and Warda talked about, how flawed and how unfair and unjust the system is, you can see it's a reflection in Abdurrahman's case. So Abdurrahman is actually a human rights activist from Egypt. He participated in the Egyptian Revolution in 2011. And in the same year, he joined the Freedom of Justice Party, which is a frontier, or you could say an affiliated organization to Muslim Brotherhood. But he mainly was a youth activist, doing a lot of youth activities like promoting youth in sports, doing human rights, creating awareness about democracy among the youth. And he was traveling in Europe, Germany, Denmark, different countries he traveled, and promoting youth sports engagement, youth involvement in democracy and human rights. In 2012, he got a scholarship in the United States, and he studied, and then the following year, in 2013, he returned to Egypt. He regularly spoke on the human rights issue, and as you know, in 2013, there was a military coup in Egypt that completely changed the dynamics, and Muslim Brotherhood was taken down, and Freedom of Justice Party was taken down, and there is a military government that is still running the country today. During the 2013 coup and the subsequent protest and violence and everything, Abdurrahman lost his close family members. His brother was injured. He had a bullet, and some of his family members were severely tortured. And he traveled to Saudi Arabia in 2017 after he got a work. After the revolution, after the Egyptian coup and all the issues that he faced, he left for Saudi Arabia with a work permit. And then in 2014, his father was detained by Egyptian authorities without any trial, without any proper charges or anything by the military regime. And then Abdurrahman engaged in a long social media and social campaign to get his father released. His father was severely tortured. And about 6 months later, his father was released. And then in 2014, in 2 occasions, in June and September, when he was returning from Europe, he was interrogated in a very intimidating and harsh manner at the Egyptian airport, at the Cairo airport, by the Egyptian authorities. Sadly, in 2014, his brother-in-law's car was bombed. In 2014, his brother-in-law was detained by the Egyptian authorities, who was a member of the Muslim Brotherhood, Freedom of Justice Party, and engaged in various activities and protests. To date, his brother-in-law is in custody in prison, and without any trial, without any proper charges, without any fair process. In 2015, his brother's car was bombed by the Egyptian state security force with a cocktail bomb farm. So after all these things, in 2015, he left to Saudi Arabia. He got a work permit and started working there. But in 2017, over the past few years, Saudi was doing a Saudiization, and they were laying off a lot of foreign workers. So Al-Mahdi's work permit was not renewed, and his visa was expiring. In around the same time, the Egyptian authorities, what they did, they issued a false criminal charge against him in 2017, saying that he was leading the youth in Egypt and conspiring or engaging in terrorist activities against the government. So, though, despite the fact that he was out of Egypt and he was not in the country and not involved in any political activism in Egypt during that time, he was targeted because of his family history and his previous work, and a false criminal case was filed against him, and an arrest warrant was issued. When he learned that, he decided to come to Canada and make a refugee claim. So Al-Mahdi came to Vancouver International Airport on October 13th, and he made a refugee claim. And the shocking part was that when he made a refugee claim, he was interviewed by a CBSA officer who, the moment the officer learned that he wants to make a refugee claim, the officer became very harsh and very aggressive towards him. The officer started aggressive questioning of him, and even took his phone and asked him for a password, which, as you can imagine, a refugee just at the airport doesn't know what to do. He became afraid, and he gave the password, and the CBSA went over the privileged correspondence between him and his lawyer. His lawyer's confidential and privileged correspondence is captioned regarding his refugee claim and everything. And in the same email chain, there are 3 other Egyptian individuals who are also discussing with this lawyer regarding their possible asylum claim in Canada. The CBSA was able to intercept and access his confidential and privileged information without without giving him any right to a lawyer or anything. So, and after that, of course, they obviously learned that he was a member of the Muslim Brotherhood, Freedom of Justice Party, and so they issued a 44-1 inadmissibility report. So the officer essentially Googled Muslim Brotherhood and terrorism and whatever terms they could think of, and they come up with a number of problematic documents, and based on which they prepared the Section 41 report, which I'll talk in a bit. But he was then taken to detention. And something really horrible the CBSA did after taking him to detention was that Abdurrahman had a disability with hearing. He could not hear with one of his ears from the birth, and they did not give him the hearing aid for weeks. And they treated him in a very mean and disrespectful manner. And then he was in detention, though like most of the inadmissible claimants who are alleged of inadmissibility are not typically detained, but he was detained because the CBSA decided to sent a liaison officer to Egypt and to talk to the Egyptian national security officers to determine their views on Muslim Brotherhood. Now, those of you who follow the international politics and the Middle East, you know it very clearly what Egyptian security intelligence and the current government holds, what views they hold about Muslim Brotherhood and Freedom of Justice Party. So obviously, they did not have a very good feedback from there. So they continued to detain Abdurrahman, and he was in detention for almost two months. And by doing that, they also exposed Abdurrahman al-Mahdi to the Egyptian authorities that this is a person who is in our custody making allegations of human rights violation against Egyptians, and he's seeking asylum in our country. So that's what is done. So the CBS officers, when they Googled and found the information, especially the information they referred in their inadmissibility report, which also later they used in his admissibility hearing, mainly come from very, very problematic sources. So Gatestone Institute is a right-wing Israeli think tank, like some of the organizations like Mayor Emit Intelligence, the Investigative Project on Terrorism. These are highly right-wing and highly controversial sources. They often regularly publish Islamophobic and anti-Arab publications. One of them is Middle East Forum that actually went after many prominent Canadians, accusing them of terrorism for their affiliation with Muslim Brotherhood. So these are the type of the information they typically use, and that's what they did with Abdurrahman. As Shirley explained, the one thing when she said that all the CBSA or the minister needs to demonstrate in an admissibility proceeding is that there is a reasonable and probable grounds. But even to show that reasonable and probable grounds, the evidence, like the evidence that are used typically in this kind of proceedings, are also highly problematic. The evidentiary, the evidence that are used, if you take them to a criminal proceeding or even a civil matter, civil proceeding, they will be thrown into trash. They will not have any admissibility because they're inadmissible evidence. They are they're hearsay. They're written material. But for the immigration purposes, it's all fair game as long as a member thinks they can trust on the evidence, they could rely on the evidence. So this is a serious problem. So the next, so based on that, an inadmissibility hearing was scheduled based on CBS's report, and I believe in 2019, Abdurrahman had his inadmissibility hearing. Now, as I stated earlier, his solicitor-client's privilege was breached, which typically should be a reason for the minister to, or the immigration division to suspend the hearing or stay the hearing procedure, but they didn't. It was specifically argued that the admissibility hearing be stayed. The tribunal rejected, saying that they would only exclude the evidence, which did not really serve any meaningful purpose in that hearing. Abdurrahman did not testify. He used an expert witness. What is more problematic about the decision when I reviewed it was that the member, which you already know from Shirley's presentation, that the members are not necessarily a member of the, they're not necessarily a judge. They could be anyone, someone from IT or someone from a business degree. They just are appointed by the minister, the immigration division panel. So they do not look into the evidence or the submissions in the same way a judge or a lawyer would, and it is reflected how it translated in Abdurrahman's case. The member actually said, the member acknowledged that Muslim Brotherhood has become more progressive, and Freedom of Justice Party had no affiliation with any violence recently. But then they went into looking into some of the academic debates and say, you know, there are like split, there's no consensus within the academics from Harvard, Columbia, and all these academia, whether or not Muslim Brotherhood is a terrorist organization. But the modern day rhetoric, this is the exact word used by the member, modern day rhetoric, shows there are suspected ties. Muslim Brotherhood has suspected ties with Hamas. So just based on this kind of allegations, based on suspicions, the member decided to completely disregard the expert witness who testified at the hearing and tons of evidence provided by Abdurrahman in supporting that Muslim Brotherhood was a progressive party. It denounced violence. It denies any link with Hamas. It had not engaged in any act of violence over like 3-4 decades, nothing. They disregard everything, the concrete evidence, because the member just decided to do that. The member had an obligation to specify the act that renders an organization a terrorist organization or engaged in terrorism. So the member decided to pick two acts of violence from 1948. Those were carried out by Secret Apparatus, which was an organization affiliated with Muslim Brotherhood back in the days. But despite the fact that the expert testified and concrete evidence were provided that the Muslim Brotherhood never had any official control or direction over the Secret Apparatus, the organization, and Muslim Brotherhood had never accepted or acknowledged any responsibility or had any official affiliation with this organization, there still those evidence were ignored by the member. So it all comes down to the member's discretion. Whatever the member decides to do, the member will do that. The way like the laws around it is so vague, around 34.1, it gives a significant amount of discretionary power to the members who are not even lawyers. Many of them are not lawyers, some of them are, and they do not have to be bound by the rules of procedure and fairness that typically a judge at a court would be bound by. So after his inadmissibility hearing, of course, his refugee claim was suspended. He was not eligible for refugee claim, so he was given an opportunity to make a PRA application. So PRA stands for Pre-Removal Risk Assessment. So basically, he is supposed to be removed from Canada, but the the IRCC has to do an assessment to determine whether he would be at risk if he is removed. PRA is normally a paper-based application process that does not involve any hearing or even any proper notice that an officer is considering your case, or no back and forth submission. You're just given one paper, say, give your submission by this date, make your application by this date. Then everything goes on. The officer reviews. You don't know how the officer is thinking, what the officer is considering, what issues the officer thinks are relevant, what Google search terms the officer was using to find evidence. You know nothing. You don't get any disclosure. You don't get any notice. All of a sudden, the CBSA calls you and gives you a decision saying you have a negative decision, now you have to be removed. And that's what exactly happened here. Abdurrahman was given a negative decision a few months later, and now the CBS has started his removal process. Now, the PRA, if you look statistically in Canada, the success rate of a PRA is less than 3%. So between 2.2 and 2.8% is the success rate that you are dealing with in a PRA application. So Abdurrahman or anybody who has been through this process, they're dealing with a 97+% risk of being removed and deported from Canada. And remember, one of the things that these people who are found inadmissible, because they're not eligible for refugee claim, their PRA is also very limited. They're only considered under Section 97, which means that they would not be eligible to be considered under Section 1996, the conventional grounds, under which it is easier to establish a case than under Section 97, where you have to establish the case on a balance of probability. So the inadmissible individual's chances of having a positive PRA is even slimmer. So I would say it's a 1 to 2% chance they're dealing with it. 98 to 99% chance they're facing that they will be deported. They will have a negative PRA. Now, coincidentally,
we just have maybe a minute or so before we want to get to be able to have the question period.
Sure.
Yeah,
so I will just wrap up. I think this was my one of the last slides. So after Abdurrahman, as I said, solicitor clients were privilege were violated, and they ended up canceling the visas of the 2 other individuals who were discussing with the same lawyer. One of them managed to come to Canada, and he was similarly detained and apprehended, and he was not allowed to make a refugee claim in a similar manner. And as I said, the entire CBS's conduct, the way they report, and also even the immigration officer, once, let's say, somebody is found a protected person and makes a PR application, and immigration officer decides that this person is inadmissible, the way Abdurrahman has been dealt with, and also the BNP and other cases I represented, it shows a clear racism within the institution and bias against immigrants, especially from certain countries, and immigrants from the Muslim religious background. And Abdurrahman is just a clear example of this. There are many other things I could say about this case, but I will just close it right here so that we can start the question. Sorry for taking a bit long.
No problem. Thanks so much, Washim. Really appreciate it. And thanks so much, Sharry, Warda, and all the speakers for your really excellent presentations today. And I'll pass it over to Amanda, who is going to be facilitating the question period. I think, a bunch of questions rolling in, so that's really great.